Hey, it's Bill Gross, and this is our Probate Weekly live stream. We do this every Thursday, 4 p.m. on Probate Real Estate. We also live stream this on YouTube and Facebook. We invite investors, wholesalers, real estate agents, attorneys, vendors, families, petitioners to get on here and talk about all things probate real estate related. As I was mentioned to one of the people before we started, I'm a real estate broker here in Los Angeles. I sell houses. I don't sell coaching. I don't sell data. I can refer you to some companies that I think are really good and can help you. But my only interest is in learning more, working together. And by working together, hopefully we all can sell more houses and give better service to our clients. We can increase our income and increase our wealth. And that's my goal behind this. So we have a special guest today. She's coming from a legal conference. And so she told me she'd be a few minutes late, which I think is fine. When you hear her, I think you'll understand why we would wait, because she's a very special lady. She's done it before and was real popular. But I don't see her yet at this time. So one thing I wanted to share with you, a question I get asked a lot, is about the court. Is the court open again? Is it not open again? What's the process look like? And I'll just share with you today, we just got a brand new letter from the court in LA County that shows the newest rules. And it says the presiding court he continues to require face masks, which has gone on for quite a while. But you do not need to show a vaccination proof, which I find interesting. Without getting into the politics of it, I got a haircut on Thursday. I had to show them my vaccination card, but I don't have to show it to go into LA courthouse. So I don't know if that's because it's more important or the restrictions are different or what it is, but just kind of FYI, that's going on. Okay. Valerie is there, but she's having tech issues. Well, the nature of technology is we have issues. So there you go. Like on my iPhone. Okay, good. So that particular update, somebody asked the question, where do I get legal updates from? So a couple of things. One is I belong to the LA County Bar Association. I'm not an attorney, as an affiliate member. And so I encourage real estate agents who want to participate in this area to join your local bar as an affiliate, and that they do that on purpose to bring in professionals like us to interact with their members, to bring service, to sponsor, obviously pay for things, but also gives us a chance to interact and learn. And there's different benefits from that. One of the benefits is getting noticed information, getting emails, getting invited to events. I don't go to many of the events, like there's a mixer. That's just not my style at all. But also there's like a chat within LA County that's very popular and attorneys use a lot to find information or ask information of each other and referrals and things like that. So you can participate in the chat if you're a member of the affiliate, at least in Los Angeles. So I definitely encourage you to participate in that if that's something that you're interested in doing. Okay, technology-wise, I see our guest, and let me see if I can find her. Really excited. There she is. I'm really excited. I felt, when I this was a long shot. I reached out to her. I'm kind of booked up for the next month with guests, and she'd mentioned that she wasn't available today. She had a conference to go to, and she said, but possibly, and she threw out the possibility. And I'm willing to hang on. I'm an optimist, but when I heard about it, in the back of my head, what I heard was Oprah Winfrey introducing our current guest today, one of my favorite attorneys, Orange County, probate, estate planning, superstar, party in a box, fantastic lady, fountain of knowledge, Shadi Shaffer. Shadi, how you doing?
Bill. How are you? How's everyone? Hi, everybody. I am doing this on my iPhone. I don't know why my computer desktop's being funny today, but here we are. The blessings of having all the options in front of us. Hi, everybody.
Well, it's amazing. This speaks to the quality of the iPhone as a camera is amazing, right? And a lot of real estate agents are concerned about live streams and podcasts and doing video. And I'd say you have in your hand one of the greatest cameras in the world, and you carry around with you all day long. So you look fantastic. So I don't know if you're using some special magical filters or what you do at the end of a long workday as an attorney to look like that.
You are so sweet. Well, I'm hosting a group of attorneys. They're all estate planning attorneys from across the nation. I'm making it sound like it's a huge group of us. We're about 11 total. So I had to look a little extra put together today, Bill. But I'd like to say, I also did it for your group, but
Oh, wow.
I came
Thank
in
you.
last minute, so I don't want to miss.
No, I'll take that. That's okay. I'll take that.
Okay, cool.
You have hit that. So Shadi, you are an attorney in Orange County. Your office is in Irvine. So give us a little background. Where'd you grow up and how'd you get into law initially?
Oh, wow. Well, I'm the first U.S. born child of immigrant parents. They were here very young, 18 and 21, with a 1-year-old, no English. And I was born in Bronx, New York. And I don't know, I think part of being the first daughter to immigrant parents, I became like an advocate for them as a young girl. And when I was 13, a woman I knew said, "You young lady need to put that mouth to use and you should go be an attorney." It was the first time I ever even knew what an attorney was. So fast forward many, many years and a lot of blood, sweat, and tears. I'm not going to lie. I went to junior college and I went to college at UC Santa Barbara. And then I actually did a master's program overseas in Spain in the area of environmental law. I never really knew anything about estate planning. And in law school, I took my first course in estate planning. And I would like to say the rest is history, but I kind of did the traditional route, went and worked for a law firm, and then fell upon estate planning. I knew it was always an area of law that I absolutely loved. It was my best scoring class in law school. And in all honesty, the reason I went into estate planning is because I felt like that was really the only area for me where I felt like I was really helping and serving my clients. I in other areas of the law, I felt like something bad was happening. Not that bad things don't happen in estate planning. When people don't plan and they die, that's the bad part. But I do so much work being proactive and protecting clients from probate and all the ugliness that I just, gosh, I can't believe I guess it's been almost 18 years I've been doing estate planning. 20 years I've been practicing. So yeah.
You started when you're 12 years old. Wow. Is that legal?
You're so sweet. I don't know. If you saw me this morning, you wouldn't say that, but okay, I'll take it. Thanks.
Well, and you're a mom. You have how many kids?
I have 3 total. I birthed 2 of them. I have an older son that I acquired through marriage, son of my heart, my bonus son. I have 3 boys, 14, 9, and 5. They all live with me and my husband.
If he lives with you, he's your son. If you put up with him in your house,
absolutely, yes.
He's your son.
I call him my son, but if you saw him, he's almost 6 foot tall, blonde hair, blue eyes. So I think that's where like people look at me like, so I'm so used to explaining it that, yeah, anyways.
You got your hands full.
Yes.
So you're licensed to practice law in California. Are you involved in any other states besides California?
I am not in any other state,
okay.
But my law partner is in Florida. So technically our firm does do work also in Florida when it makes sense. The reason why I say that is because, at the end of the day, we want our clients to be serviced properly. So if it's better that they have a local attorney in Florida, then great. If for some reason it works that we help them, then we could do that too. So yeah.
Got it. How is the practice of law in California different than other states that as far as you're aware of? I mean, you're not practicing necessarily yourself in other states, but how is it different?
Huge difference. So unfortunately, the United States doesn't have a uniform rule for when you die and probate and whatnot. I think at one point we have to get there, but every state is so unique and different that the laws and the rules are different from state to state, right. Especially in the area of estate planning, wills and trusts. California actually is the worst state in the nation still. I'm embarrassed to share, to not have a plan. It's called dying intestate. I don't want to get into the legalese because that's confusing and boring. But if you don't do your plan, the courts have a plan for you, which really sucks, if you don't mind my saying.
Yeah, the way I put it is if you don't have a plan, the same people who designed the DMV and that level of service will take care of your assets for you.
Oh my gosh. You know what, Bill? That is the best analogy. Can I use that?
Please.
I will say Bill Gross.
You may have to.
Probate realtor in Southern California. I'll coin this, but that is a great analogy. I have an analogy when I discuss probate about the cost. I say it's kind of like Disneyland, super expensive to get in. And then once you're in, it's even more expensive. It's like you breathe and you're paying for stuff, You
think you pay a lot to get in and then you realize, right? And the fee and the cost.
A drink,
I'm curious, it's probably a little different in Orange County than LA County, but the reaction I always get from customers is when they find out what the advertisement of the probate costs.
Yeah.
in a newspaper that nobody reads.
Yeah, 980, 950, 940. Yeah, it's called the publication. And people, my clients are always like, why am I paying $900 some for this? Well, you have to tell the world, that, your loved one died. And they're like, and we're still doing this on a newspaper? Yes, we are. It's like,
how does that even work?
Now, I don't even know who reads it.
Well, I used to go to court. I'll tell you who. I'll tell you exactly who. I used to go to LA County Court every day. And, back in the day when you had to file things physically in the courthouse, down the hall on the second floor, there was, at the end of the hall where most of the probate departments were, then you turn down the right, there was like a little alcove where there was a little cubicle area for 2 or 3 of the newspaper companies. And you go there and you could place your order and write them a check or give them a credit card. And they would print copies of the newspaper, put it on the bench right outside the door. Wow. And I was like, why do we have to publish this? Nobody's reading it. The only copies in the world are right here. Who else reads this thing?
I know. You know what? So COVID has the silver lining, has blessed us because it pushed our government, all of us, right, into being more tech conscious, right? Mm-hmm. And tech accessible. So I guess that's the silver lining, right? We could do appearances now through Zoom and online. So that's the blessing. But there's still so much red tape and bureaucracy in any government-led, process, like your comparison to the DMV. Probate is not for the faint at heart. Takes 2 years to go through. Now with COVID, it's taking a little longer. I mean, 2 years is it used to be like a year and a half, but now it's 2 years because of COVID. I wouldn't say it would take longer than that. If your attorney's doing their job and getting their stuff done on time and meeting all the deadlines, you can finish it within the 2-year mark. If you're lucky, you could do it within a year and a half, but that's it. That's as fast as it's going to get. And the problem is, you could go cry to the judge and tell them all the sob stories. My kid's this, my mom that, my grandma this. And they don't care because they go, well, don't yell at me, yell at the dad or uncle or father or parent that didn't do their planning. Right. So, if you don't do your own plan, the court system has one for all of us, and it's not exciting and it's not cheap. It's expensive. I make 10 times the money in probate, 10 times. Like, I don't need to, I tell my clients, like, you don't want to spend $3,000 or $5,000 on a trust plan. That's fine. There are lower cost trust plans, by the way. So don't hold me to those numbers, but that's the range in our firm. You're spending 10 times the amount in probate court, just $1 million property. And you're looking at $1 million market value property. Parent dies, the property goes to the kids, or they want to sell it, divide it, or do whatever. And if that $1 million property was not under a trust plan, it's literally going through probate, and the fees are bare minimum I'm doing fast math, $35,000 to as much as $65,000.
Right. And that's if nobody objects, they don't drag it out. If it, and of course, you have a house with a reverse mortgage or a mortgage on it, your equity is just getting eaten away every month. So there's both the cost of the probate, and then there's the cost of not being able to manage the assets at the same time. It is really very expensive and very
That's a very good point, Bill. I've got a lot where they're struggling to pay the property taxes. The kids are like, well, who's going to pay for this? Do we have to pay for this? So meanwhile, you're getting penalty fees, like you said. I've got a case right now where the reverse mortgage lender's starting foreclosure, and I'm trying to push the parties to agree, there's like 2 kids in the house, not children, but adult children still living in the home. Always. They don't want to leave. It's a mess. It's sad, but
I think we do this all the time. And one thing I've noticed that's changed recently, tell me if you've seen this on reverse mortgages. It used to be they were like a lender. If you called them, they didn't want to foreclose. They would work with you as a listing agent. I'd send them a listing agreement. I'd show them it's in the MLS. I'd show them the days on market that we're doing what we're supposed to do. Now they assign the mortgage to basically a foreclosure company. It's a legal processing company in San Diego, and they're just running the timeline as fast as they can to foreclose. And they're fine with you doing an ex parte and delaying it because they're going to add those fees onto the mortgage balance. They're glad to do it. They're a law firm, and they're going to end up charging you more and more and more as you try to fight the foreclosure until there's no equity left at all. So do you see that happening as well in the reverse mortgages?
Yeah, well, I will share. I think because because it's been happening where reverse mortgages are tying up into probate, there is a rule that they have to give families 9 months from the date of death. Right. So they do get 9 months. But here's the thing. Just because you're given a certain time period doesn't mean that the reverse lender has to just sit back and not protect their interests. Right. So what I'm finding is, they'll oftentimes refer it to an attorney because, people say, oh, well, it'll be done before then. And then what do? They push it. And so if the reverse mortgage lender doesn't file suit or file certain legal notices and foreclosure proceedings, they're not protecting their interest in the note against the property. So unfortunately, the law and the real world don't meet in perfect unity, and they have to do what they need to do to protect their interests. So I'm seeing that a lot more than, especially now with COVID. Yeah. I think lenders are not confident that the family or the heirs can work things out and figure it out in time, unfortunately. Right. So that's happening.
The common case is, I live in Orange County right now, where there's four sons or four siblings. There's the one who's living in the house. He's been living there for free for 2 years while mom or dad were sick. The mom and dad passed, and he's hiding the notices. He's not telling anybody there's no payments. He's living there for free for 2-3 years, doesn't have a job, really can't launch into life. And then the other siblings, they don't want to throw him out and make him homeless, but that's really his only option, right? What do you do in those cases? You feel sorry for him, but what do you do?
What the case I was bringing up, actually, so it's kind of hard to explain, but I'm not the lead attorney in the probate. And this, the mom was my client. And I told her, so it's a crazy story. Her husband died. She came to me for probate. And I kept saying, Linda, you need a trust. You need a trust. Now that we resolved all this, you need a trust. She didn't do a trust. I'm like, oh my gosh, why wouldn't you do a trust? So she didn't do a trust. It's in probate. The brother got an attorney, and the sister keeps calling me, like trying to explain to me why she wants to stay living in the house. And I'll call her Sarah. And I'm like, you gotta leave. You gotta leave. And it's been like literally 10 months. And I finally said, it's going to go into foreclosure. It's a reverse mortgage lender, Bill. So I'm like, but also part of my confusion is, if you don't ever leave, you're never going to get the inheritance from your home, the home that's owed to you because you're one of 2 children, but and she kept saying, but I don't even have any money to leave. So I called the attorney so we could figure out a way to get her some money to help her move, pay for a down deposit. But she's on the edge, the daughter, because she doesn't know how she's going to cover her rent the next month. It's a sad situation. I have those conversations with clients, Bill, because when I hear that adult children are living at home, it's kind of like red alert. And I the other day I had a heart-to-heart with an elderly couple, and I said, but do you understand that if you don't have this conversation with your 55-year-old son, you're leaving it for your other 2 kids to have it. And then you're going to create friction between your children. Why would you do that?
Right.
These are touchy subjects. These are hard topics.
These are hard topics. I think sometimes people, default to sympathy. I have a case actually right now. We're getting ready to close escrow, where the decedents had a girlfriend who came back as he was dying and was helping him a little bit, and he passed and was living there for free, of course, into drugs and all kinds of craziness. And the family wanted her out to sell the house, and somebody said to me, don't you have sympathy for her? And I said, the wife, who is in a nursing home, and she's in one of those Medicare low-income nursing homes because she has no money other than this house. But this girlfriend, who really doesn't belong there, is holding up the sale of the asset that she's entitled to. And by the way, the decedent worked his whole life. He was a war veteran. He was a war hero. And he left the house to his wife on purpose to take care of her. And so I'm sympathetic to my client. I'm not sympathetic to some squatter who is just, violating the law and using it to their advantage.
Yeah. No, I mean, I hear you loud and clear. A case of mine that settled 2 years ago, 8 children and one child was like, no, I'm going to stay in the house. I was like, really? Wow. You don't think your other 7 siblings have a right to their share of this home that was owned outright? They're all going to split like $800,000. You don't think your other siblings deserve their $100,000? I mean, I don't know.
Or that your parents, they didn't leave it the way on purpose?
They didn't leave. This is your mom and dad's wish that all the kids get their equal share. Yeah. you know, it's a, we are living in some challenging times. And I definitely think that we all have a duty to contribute, right? And be an active member of society. But I know there's a lot of so many layers to this, Phil. Mental health, addiction. I mean, there's so many things, disability, I don't want to pass judgment, but it's, right. But look, at the end of the day, we have a job to do. And I'm really genuinely trying to help everybody, right. Like, let's get this resolved so that everyone can get a little piece of what they're owed, what right. is rightfully theirs legally. And so we can move on. So I do want to say one thing, because I'm on my phone, unlike my screen, I can't really see the chat. It's like, it comes up, but then it goes away. So you're going to have to be my eyes for that.
I got it. I got your light teed up, but I can't just throw them out because you're going pretty quick. So I don't want to rock the boat there. You got some momentum. I stand back and let you go a little bit. So we wind you up. We let you go.
Don't let me go too much. This is dangerous.
Exactly. Okay. So we got a great question from Veronica. She says, when you publish notice, is that to find errors? And the answer is kind of yes and no, right? The law requires it, yes, but theoretically errors can pop up as a result. But then how do you find errors? So let's imagine that you publish and some errors pop up, that's great. But there are other ones and you know of their existence, but you can't find them. What do you do to locate, to notice other errors that might be around?
So first of all, typically publication, it's to put everybody on notice. Family members, but also it's really for creditors too. So if anyone has a claim against Shadi Interstate, if I owe someone money, they could be like, oh, wait a minute, she owes me money. Let me come tell the court, hey, this woman owes me money, and put it. Also, by the way, just a side note, when you don't have a plan and it goes into probate, now what you did is made it super easy for anyone that has a claim against you to file a one-page creditor claim, and if it's a legitimate claim, they'll get paid the money. The judge doesn't care if Shadi's 3 boys only end up with $100 each. She'll be like, she owed them money.
Doesn't care at all.
Yeah, no, doesn't care at all. Yeah. So back to your point about publication and errors. So when we file a petition for probate, by law, we as the attorney representing the family member who's being the administrator or petitioner, we actually have to go through them to give notice to all known heirs. Okay. Typically children, spouses and children. Okay. That's there's a priority of who is supposed to get notice. If you don't have kids, then it's like, there's a sanguinity chart, of familial chart. If it's then your siblings or parents first, if no parents and siblings, that's how like the third cousin gets notice, right? That their cousin died and now they're an heir. If we don't have the contact information of an heir, there's heir search companies that we could hire. I believe it or not, in one of my cases, we had an investigator hired once so we can like locate the person, but there's heir companies and search companies to find those heirs. And there's a whole process by which the court control. It's not like, oh, I tried, Your Honor, and then we move on. Oh, no. Like, we have to go through a lot of steps to make sure that person's notified, right? Because imagine like I have no children, no family members. The courts want accountability, right? They don't want the neighbor to get, my money because it was my neighbor, right? So it's all about accountability and protecting also people that need protecting, like seniors from getting taken advantage of. My grandma could be 95 and die. And then if the neighbor gets the money and I get no notice, it's like, wait a minute, my grandma didn't want the neighbor to get the money. So you kind of could do some digging and so on. So it's about accountability too.
So one of the things that you see happening, I think, more commonly in the past is in those last, year, months, weeks, days, documents are signed, and all of a sudden there is a new girlfriend, there's a new caregiver who had a special relationship. She's not a caregiver because legally that would cause a problem, but she's around a lot providing, or the one daughter took care of the parents at the end, comes up with a will, hard to read the signature, hard to read everything. So talk about that a little bit, how that's become more common. What do you do to protect families from that? Obviously, estate plans will protect it to some degree, and do you see that more commonly happening, and what can they do?
It happens. It definitely happens. And even if that's not happening, if someone, even of sound mind, is making that decision, a lot of times children then dispute it, especially if it happens like close to the end. So obviously the biggest takeaway is do advanced planning, right? Try not to wait till you're sickly or aging to do these things, because there's more room for people to question that. But there's protocols. First of all, as an attorney, we can't just draft, trust documents. Like you come to me, Bill, and you've got like 5 kids and an amazing, relationship with them. And then all of a sudden you want to leave it to the caretaker. As an attorney, I have to kind of wonder about that, right? And the caretaker sitting next to you in my office, I actually would never allow that. Attorneys shouldn't. We would meet with you alone. We're not physicians, so I'm not really here to see like, oh, does Bill have mental capacity? But, I could, you could get an idea if someone has got the capability or not. But then there's other protocols. That's why there's a notary involved. That's why you have to have witnesses for some of these documents. The witnesses have to be unrelated to the planning document, not named in the document, 18 and over. So there's some accountability there. And then there's a whole other standard of care for things. So when someone has like a bedside planning, when they're sick, I don't really sometimes take those if it's like, oh, hey, I'm in the hospital, and they sound fine and you see them, but like, oh, I want to leave it all to my girlfriend. I might be like, and you have like 5 kids. I might be like, well, when you get out of the hospital, let's talk. I just don't want the liability as an attorney, because here's the thing. Later on, it can come back to me. I mean, if the errors feel like I did something that I shouldn't have done, I can get in trouble legally, as I should. So there's a whole check and balance in the system. But if someone wants to complain, just to complain, for example, I did resolve a trust recently where 2 boys, son lived here, and mom at the end was like, look, this son took care of me. She told me herself, he does all my caretaking. I want to leave him 75, and I want to leave my son that's out of state 25%. I did it. It is her choice. If I don't do it, someone else will do it for her. She completely was very high functioning. And, she died years after that, where there was this history pattern. Now, the son that was getting 25%, of course, was he upset? Absolutely. Does he have the option to dispute it? He does. Yeah. He better have some really good. Now, on that side of it, you need proof. You can't just be like, just because I didn't get 50%, I want to dispute it, right? Or I think my mom was ill. Well, you're going to have to prove that back in 2018, when she met me with the attorney, did she lack capacity? Are there medical notes or medical documents to back that argument from that child? So it's a fight.
Do you know what the standard is for me as a real estate agent as far as capacity? Like at what level am I supposed to notice things, or what would be something that would trigger my question as their capacity? And do you have the same standard? You're not a doctor. You might have to get a doctor certified for certain things, but on its own, do you have a different standard being an attorney than me as a real estate agent? And what is that standard where you might say, hey,
personally think Bill, I personally think as attorneys, we have a higher standard of care because we know the law and we should know better, I don't know what the Department of Real Estate in California, what their litmus is, but I think we all kind of know, like if you know that client's confused about what they're signing, I stay away from that. Like that makes me extremely uncomfortable because there's going to be a pattern. I think that there's always a history of things. Now, I did have a client where he was very, very clear-minded, did not lack capacity whatsoever, but he had some kind of hand tremor. And, someone was like, oh, but look at the signature. And I'm like, that's not a basis for that. I know I'm not really answering the question per se. I mean, the reality is that in a couple of instances, I did once ask, I'd kind of like a medical note. That's kind of an extreme thing to do though. Like that client doesn't have to bring me a medical note from their doctor. But if you have doubts, I'd say when in doubt, it's not worth it. Right. You know what I mean? Like if you're doubting it, that's an instinctual thing that you really should kind of back out or try to get the support. It's not a perfect world. We're sometimes going to do things too that we have no ill intention. And just remember, someone can always complain and always file a lawsuit. That is what I've learned in my last 20 years. So don't let that shake you. If you believe in what you did and you don't feel like you did anything wrong, then, at the end of the day, like why there's not enough money in the world for me to do someone's trust at the expense of hurting someone. I don't know.
Sure. My father was an attorney. He used to say, anybody can sue anybody for anything. Doesn't mean they're going to win, but anybody can sue you for anything. If they're upset, if they think if they're cheated, if they feel cheated, they have the right to sue you. It doesn't mean they're going to win. Doesn't mean you can't collect damages and such against them. But yeah, and I think the challenge, having been through this with 4 sets of parents between me and my wife, is that some of these people have different moments, right? They're lucid most of the time, but occasionally they have problems. It might be times of the day they have different problems. It might be medication, changes in medication, right? So, this day they're normal, but then the next day, for whatever reason, they're not. And so when people are adamant, they know the person's clear or they know the person's not. It's not so simple.
No.
It's not constant. Their abilities go up and down over the course of time.
Yeah, that's a very, very good point, which again is more reason why advanced planning in all aspects of life, not just estate planning, right? But every type of advanced planning, right? Financial planning, memorial care planning, even real estate planning, right? You don't want to be doing things at the last minute because you're not going to make good decisions.
Yeah, success is always about planning ahead, preparing for success, for sure. Okay, we've got a question in the chat box from Christopher. He says, many probate sales require court confirmation. Why do so many LA probates not have full authority? I can tell you that in LA right now, we have about 67 scheduled, about 50 a month go through LA County Court requiring confirmation. There might be 500 sales. There might be 50 with 500 sales a month. There might be 50 with court confirmation, about 10%.
Oh, wow.
Now, Orange County, it's a lot less. It's a very rare thing, it seems, in Orange County, yes?
It's rare, I think. Okay, so demographics, income. So here's the thing. Okay, a couple of factors. The petitioner, if they're not credit worthy, it's going to be hard for them to get full authority. That's one. Two, if there's any family member or heir that's objecting or disputing it, that's another reason why it's going to be difficult to get full authority. Right. Also, if there's other extenuating circumstances, sometimes you might have a lot of probates in LA, but then the individual petitioning is actually not in California, is out of state.
Right.
That court's going to be less inclined to give full authority because they have no control over that person out of state. There's a lot of different factors as to why. One of the big reasons is the ability to get bonded and your credit worthiness. So if you're listening, right, just because your mom passed and you're the sole child doesn't mean the judge is going to approve you as the administrator or executor, because the judge's thought process is this. Okay, you're asking me to approve you to manage your mom's estate, but you've got like a 500 FICO score. Well, why would I put you in charge of her bank accounts and the sale of her home if you're not like credit worthy? I know there's arguments about FICO scores and whether that's a good, but you get the idea overall. So at the end of the day, another issue of probate is a judge decides who gets to become the boss of your hard-earned money and assets. Like why, I always tell clients when they come and they go, but I don't know who I want to pick. I'm like, listen, the devil you know is way better than the devil you don't know, which is whoever the heck the judge wants to select, or worse. I have some cases where, the spouse dies and it's maybe a second spouse. And then the surviving spouse is like, the daughter's the petitioner. And here I have been the wife for 20 years living in the home and she wants to administer these assets. Like, well, hello, but spouses do have priority and there's a whole other thing. So believe it or not, someone else could file the petition first and have initial priority until someone disputes or objects. So that's why I think I will say something else too. I don't know if this is, kosher or not, but it's more work as attorneys, as probate attorneys, to file a petition with full authority. So we have to be, on our game, know how to assess the case in order to see if our client's going to be accepted to get full authority or not. So I think in LA, you've got a lot more going on there, right?
I think you're right.
Properties of large value, many generations, people all over, different demographics perhaps, and maybe that has something to do with it too.
I think you're right. So just to follow up when Chris asks, so if the administrator or executor isn't credit worthy and can't get bonded, then the limited authority allows them to get appointed, but without a bond. They can't qualify for bond. That's the alternative.
Yes, that's correct. So then it's limited authority. So then, therefore, when you want to come to sell the home, you have to get court approval in order to do that. But with full authority, you are allowed to sell at market, at market price, of course, and you're allowed to sell. Now, also sometimes if there's an interested party and they ask for a special notice or they petition for something, like, hey, I don't really trust this person, they could petition to request it having to go through court too, and so on.
There's an objector, the ones, and I always caution, before you object, talk to your sibling and see if you can't get into some deal, because once it goes limited authority, you're forcing this whole court confirmation process. You can't undo that once you force that.
Yeah, that's a really great point, Bill. I mean, I'm like sitting here going like, I think he's the attorney. I think the tables are turned here because you're so eloquent and, you are really very well versed in the probate area, Bill. And, not all realtors are. I could tell you've had extensive years upon years of experience in probate. I've learned things from you. And so, yeah, it's better to work it out if you can.
Always better to work it out with the person you hate than it is in front of the judge with the person you hate. Because you're still going to be with the person you hate. Yeah. And again,
because you're in control. Now, if there's an issue of like trust or something, I'll tell you, I had one case where my client said the brother was the petitioner. I won't tell you this. I won't tell you what his profession was. And they said, we don't trust him. And so we asked for certain things and a bond. We didn't waive bond. He ended up stealing from the estate. So we used the bond company. I filed a motion and the bond company reimbursed the estate for the money he stole. So people go, well, what's the point of a bond? There's a point to it. It's a security so that if the person skips the country and goes to Costa Rica with the $500,000 sale proceeds of the home, the bond is the protection for the parties, for the heirs, if something like that were to happen. So there's value to that. You can waive bond, but all parties have to waive bond.
And I think sometimes people don't understand. They think, well, can't the judge, decide this or that? And the answer is, in a perfect world, they might, but they have so many cases.
Oh,
such when you listen, to the call of cases in the morning, where they have basically the consent calendar. There's so many of those to get through in the time period. The judge has so little time on any individual case on most of these matters that the default is, why should I rely on remembering I met you in court when you can't follow the procedure that's required? And so it's not necessarily just they wouldn't like to be more accommodating. It's the DMV. It really, the judge is not. The judge is like the DMV commissioner. Like he's not, or she. They're not like a DMV employee, but they're serviced by the DMV basically, and it's tough.
And again, a great analogy. And look, they are overworked. They're looking at stacks upon stacks. They cannot manage all that. Clients are like, well, aren't they reading the case? Not really. Maybe like 5 minutes before they go that morning on the bench. I hate to say that, but there's truth to that. And, sometimes I'm like number 47 on the calendar.
Right.
And that's not just one calendar a day. The judge has got like 5 different times or 4 different times in that day where they have hearing spots.
So I'm not sure how it is in Orange County and LA County. When you get the authority, the attorney prepares the order, right? So the good attorneys prepare it ahead of time, but most of them wait till afterwards. They start to prepare it. They prepare it wrong, gets kicked back 2, 3, 4 times. You know in San Bernardino that the court prepares the order and just hands it to the judge, and they sign it right then and there. It's like, what is up with that?
I'm like, let's all pass away in the county of San Bernardino.
Yes.
We discovered that the other day. Yeah, we've been having issues with this, and the orders have been crazy. I'll tell you something funny. We've submitted orders maybe even a little too fast, and it's been rejected because the clerk's like, well, we didn't get the minute order from the judge. So then they reject it. Then it comes back to us, and then we're having to by the way, my clients kind of get frustrated. Like, well, Shadi, the hearing was a month ago. Where's the order?
Right.
I'm like, look, I hear you. I'm just as frustrated with you. Remember, as the attorneys, we don't get paid till the very end. I told a client of mine recently, I go, I've been working on your case for like a year and 6 months. I'm like, I want this settled just as much as you do, because
Right.
I would like to get compensated for the last year and a half of work.
Right.
So it's a hard thing.
When
It
we
takes a long time.
we do court confirmation, when I represent an investor, we buy them, I tell them theoretically you have to be able to close within 10 days from the court date. But the reality is it's 10 days from the receipt of an approved signed order by the judge. If the attorneys know what they're doing, that can be 30 days. It had to take longer, right? Because the form is not so simple. So here's the softball question of the day for you, because I know this is what you do as well, and you also have other members in your firm. What's the benefit of putting a home in a trust?
Oh my gosh, a lot of benefits, huge amounts of benefits. Okay, so actually,
this is such a soft question. Like, you can't even get your arm around how beautiful this one is. This is
it's like so many.
You talk about this all day.
Oh my gosh, where do I start? I'm such a trust nerd. It's kind of like corny. Anyways, okay. So first of all, autonomy, right? So the moment I put my home in my trust, I control it, and the people I select control it, right? To rent it, to sell it, to do whatever they want. Talk to the county assessor's office, deal with property taxes, get insurance on the property, repair it, list it for sale. You get the idea, right? It's not just if I die. I could get incapacitated and need to downsize, move closer to family because now I've got a rehabilitation issue. I mean, life happens. You have no clue what to expect. So you want to have the freedom to be flexible with life. And the only way you're going to have that freedom is if you put it in the trust. So imagine this is Shadi's water bottle, right? Let's just pretend it's a $500,000 property. If I die, who controls this puppy? Just because it's my spouse on paper or my 3 kids, they don't get to automatically do whatever they want with this, right? So the legal system says if Shadi didn't put this in a trust and appoint people to manage it for her benefit, then we're going to control it and we're going to tell you what's going to happen. And it's just going to sit there. You're not going to be able to do much. So that's one benefit. Another benefit actually is some element of privacy. When I die and I have a trust, it's not all public for everyone to see what's going on, right? Probate's all public. So that's another thing. I'm not tied up into the courts. Again, my trustee can manage the property and do what they want. I mean, they could sell my property as easily as 30 to 45 days after I die if they wanted to. If my kids needed it, my family needed it, they need to pay for funeral expenses, whatever the case may be. If my only asset is the home, let's say. Here's some other amazing benefits. You actually leave it in a more protective way to your beneficiaries. So let's say I have one child, and I'm going to leave this house to them, but they've got this huge judgment against them or an IRS claim against them or something, right? If I leave my home in a trust to my child or any beneficiary, if you don't have children, fine. Anyone you care enough to leave your stuff to, that you're leaving it to them protectively. Okay. So you're giving them like creditor. If the trust is drafted right, not all trusts are equal. If drafted well, you're leaving that the money, life insurance, the house in a protective way to the beneficiary. So if the beneficiary is on disability, Medi-Cal, you can leave them $1 million life insurance money. But if you leave it through the trust, you're giving it to them protectively. I could leave $1 million to my 3 boys, and I could leave a trustee in charge of the money to divvy it out, use it for education, and give it to them over their life versus, hey, kids, mom died. She didn't have a trust. It went through probate. Now you're getting it all at 18. Enjoy the $300,000 you just got that you're going to spend in the first few years. Those are just some of the basic benefits that I could think of like quickly off the top of my head. There's so many. By the way, one last thing I'll tell you, California changed their rules for Medi-Cal recovery. If someone goes in a nursing home, it used to be when that parent died, the state could recover. Well, yeah, they should, right? Hey, we've cared for your mom or dad. Give us some of the money back that we spent on their care. It's amazing. Now they don't let you get to the primary home if it's in a revocable trust. So my belief as an estate planning attorney is like, look, the state is even realizing how important this is, how overwhelmed the probate court system is. I believe they did it for that reason. Well, they want people not to be homeless, right? They don't want families to be out of a family home and so on. So there's so many benefits, benefits.
I say, and again, I'm not giving legal advice, but just business advice. And what I've observed, anybody who owns a house in California should have a trust to protect it. Anybody. The biggest misconception is people tell me all the time, well, I don't need a trust, I have a will. Like, oh, whoa. A will is just the ticket to go to probate court with a will versus no will. It's no different. It's in the DMV, there's two lines, with a will, without will. They both get the same service. There's no real difference. But the trust is a whole different experience. And if you don't know that, if you have questions, you definitely want to consult with an attorney, evaluate your case, because it's a big
A will does not avoid probate. That's a, there's
no,
a lot of
some states, it might in some states. I think it may in Texas or some other states, right? But not in California. No, you're going to the DMV with a will.
Point. It's just like an I love you letter that still goes through court. It doesn't avoid probate at all.
It's just like the DMV. There's a different line you go to with a will versus not a will. You're still at the DMV bill.
Good point.
Yeah. Okay, so we have another question. Remember, it says, how do you contact an attorney or whoever to list a probate property? So, I think sometimes companies that sell probate data or sell probate coaching to real estate agents or investors make it sound like we'll just buy the data of the probate filings, and there's a list with the attorney's name and phone number, and just call the attorney, and they'll refer you listings just because you cold call them to do that. Now, we're obviously in a very competitive market, Orange County, California, LA County, California. That's not really how it works, is it? I mean, I'm sure you must get calls from realtors who are now certified as probate experts, and because of that, expect you to go, oh, wow, that's great. Let me put you in my Rolodex and make sure I send you every refer. Is that how it works or not?
No, it's so hard. And I'm like, I'm someone that's like, gosh, I wish I could like give referrals to everybody. But the reality is a lot of our clients come to us. First of all, I get these letters right when I file a petition for probate. Right. And it's like, hello, the wife is still living. Why are you sending me a letter asking me and I get it. It's marketing, and I respect everyone's need to like market and whatnot, and, fish, if you will, or hunt, or whatever you want to call it. But no, it doesn't work like that. I think you have to really be meaningful, create networks, join organizations, add value. Just sending a letter. It really pains me because I feel like it's environmentally so horrible, because like all these letters and marketing pieces, and that just really kind of end up in the trash. Like you look at them, and in the beginning, I was like, and then I was like, after 5 years of that, I was like, okay, trash, and right. I will tell you a few times, I've had a few realtors call and like pretend it was like case related to get us on the phone. And that is really not cool. Like I would get so upset. And I've even seen some really odd marketing pieces. I'm going to tell you one thing I recently saw that really kind of ticked me off a little, to be honest with you, because I feel like it's very misleading for the layperson, right? The family member who's in probate. They took the probate petition and they like cut the top part off, and then they put their own information on there, like realtor, let us know if you want. But my client called me like, oh my gosh, I got a and I'm like, what? You got a court document? Send it to us immediately. And it was a marketing piece. And we were like, oh, that's tacky. But, creative, but tacky.
Yeah. I always feel like if the base of your business is fooling people into working with you, you might consider a different career or business. So
yeah, it's so hard. And, a lot of our clients, like they want to keep the home. People are still living in the home, or, here's the thing. My mom wants me to use her realtor, or my cousin's a realtor, or, she wants me to use the realtor in the neighborhood that farms that neighborhood, I try to give my clients some other options, like, hey, here's another name or two, call them. But it's not always the case. Like right now, I've got a lot of probates where they're not, and I don't have a lot of probates, even though I do a lot of probate. I don't have like a mass volume. I'm not a huge firm. I would say a good half, maybe even a third, are not selling the property.
Right. Well, like most sellers, and those who do sell, the other part that's true, that you may not even know this, is they might sell 2-3 years from now. Like most sellers don't think they sell, and then something changes, and 2 years down the road, they do. And so you have to earn a relationship, I think, to put yourself in that position. The one exception that I think attorneys are too casual to let the customer choose without at least interviewing is on court confirmation. I feel like that's a specialty that I feel like, look, if you use your own realtor, I'm going to look at that property when it's filed and maybe have my investor buy it on the cheap because you're making a mistake. And I see that all the time.
I agree with you there. Absolutely. So I will tell you, I'm very opinionated if it's limited authority and it's a disputed a probate, I actually say to them before they hire me that I would prefer they go through one or two, realtors that we work with, because I've had some really scary situations.
Yeah.
I mean, I look at all the listing agreements, and especially when we're in escrow on estates and even my trust, I have to look at those documents with a fine tooth comb, because I found a couple of times where I forgot the name of the form, but it had my client's name and social on there. And I'm like, wait. They're not selling this property. The trust is selling it, or the estate of is selling it. Right. And that could become an IRS nightmare for me and the CPA. So that's a really great point. Yeah.
Yeah. So Christopher, again, a good point here. He's attended probate court in various counties, and he sees probate cases being continued because of errors and oversight by the attorney. Now, sometimes it's not the attorney, and you don't really know, but there are plenty of times it's pretty obvious the attorney filed the paperwork and it was incomplete, and they didn't, they got caught. And in the old days, you'd be in court and the attorneys would come in, and the judge would say, "Do you check the notes?" The attorney would say, "Well, what are the notes?" You knew right away they know what they're doing. So he asks, do the attorneys offer a concession to clients on the fees? Do they lower their commissions or their costs? The answer is, there she is, no.
You know what? I'm very kind of obnoxious when it comes to my own field of, my colleagues. I think there's a lot of very sloppy attorneys. Maybe they don't mean to be, lack of integrity or workmanship. Sometimes they're just solos. They're doing their best. I mean, I don't want to diss them all, but I find sometimes it's just a lack of organization, lack of management. Probate, I didn't just jump into probate. It took me years as an estate planning attorney before I embarked in probate. It was hard in the beginning, I'm not going to lie, but right now, like my probates, I'm like always ahead because I have to be. To me, I don't know. I feel like when clients hire us, I feel like I have a huge duty to make sure I really do their job as efficiently as I can. Have I made mistakes? 100,000%. We're all human, but who you get, I don't know. I think you have to be really careful when you're hiring someone, because I think it really matters, especially in probate. My biggest pet peeve is when, oh yeah, we'll just continue it. It's like, no, people are waiting for this. Maybe because I didn't come from money, Bill. I don't know. I come from very blue collar family. Behind every case is a family that's waiting for this to get settled. They need the money. So I really push my team. I'm very lucky. You're only as good as your team. I have the most amazing paralegal that helps me with my probate cases. I sing her praises daily. She makes me look so good. If it was just me doing it, we would be having continuances for sure.
Yes.
She helps me.
I think
we're always pre-approved. I'm very thankful.
Nice.
Yeah.
There's no reason not to be. Something's wrong.
There's no reason not to be.
The attorney, the probate attorney who works for the judge reviews the case, gives you the notes. They tell you what, at least in LA and in Orange County, you know what the problem is before the hearing date. If you don't even try to fix it by the hearing date, then you can ask for continuance and not waste everybody's time. But if you show up and the judge has to tell you no, it's just, you're not doing a job. I hate to say it.
But I will say one thing, and I will tell you this. I will tell you that sometimes we have no control over it. So I'll give you an example. We filed everything like months in advance. We're waiting for probate notes, waiting. And sometimes they're giving us the probate notes literally like 5 days before.
Right.
And you don't have any time to cure the note.
Right.
So a lot of times it makes us look bad and the client gets upset. But I'm like, look, I submitted this 3 months in advance. The court didn't look at it till 5 days before the hearing. And I have to submit everything 5 days before the hearing. There's no way I'm going to be able to submit it that same day. So a lot of times it's not our fault too. So to be fair to my colleagues too, at the same time, we are at the whim of the probate system, and it's not an efficient system. I've had, by the way, now with COVID, some judges are sitting on the benches asking for things. My paralegal and I are looking at each other like, I've never had that request. What the heck's going on? I mean, we've had some crazy stuff happening. That's not in our control. And now they're postponing it and the client's getting upset. So to be fair too, you want to know both sides, because it's not always that the attorney's not doing a good job.
Okay. Well, I think maybe Orange County is a little different than LA in my experience, but I've seen too many times when attorneys ask the question, what are the probate notes? Like, something's wrong. Like, I feel like the judge is like, can I have your bar card for 1 second? Let me hold on to it. Go back to class, learn how to do a probate, and then come back and I'll give it to you.
Yeah, if you're saying what are probate notes, you should have co-counseled with someone. Like,
exactly.
That's frightening. Yeah.
Don't say that to the judge. Like, that's just
it's
tell
like
the teacher you didn't do your homework. Like, that's just wrong.
Kind of crazy. What's trust, Your Honor?
Exactly. Question from William. If you're there, William, this will be the last question because we got to wrap up here real quick. William, you have a question for
Hey, how you guys doing? Bill, I just want to give you kudos, man. This is so insightful and enlightening. I really stepped my probate game up. And, I just want to thank you, man. You're a wealth of knowledge.
Well, thanks.
I do have a question. I'm in it's more of a trust sale. In a nutshell, the deceased passed and they refinanced, but did not put the trust back in the property after they when you refi, you got to take the trust out of the eccentric. So they didn't do that. So we had to file a headstead petition. We did that. The court date was in November. The judge verbally accepted because we're ready to close. We're just waiting on the formal sign off
Order. But in LA County?
In March.
In LA County?
The judge verbally agreed in November.
What county are you waiting on? What county is this in? There you go.
LA. So what's the turnaround? Can we push for to expedite it? I mean, can the attorney,
has the attorney given you any feedback on, they could email the probate examiner and go, hey, what's going on? We have the hearing. It was approved. Where's the order coming?
Probate examiner. He says that I need to just take a note. He said that the clerk says we just have to wait. I said that's it. That's the only thing. Probate examiner. I'm talking to the estate because they hired the estate planning attorney. I'm like, he's not taking any other efforts. They're like, well, he says we just have to wait. We're in line. I'm like, there's nothing else he can do.
If I could add one piece is, I've been in these situations. If you have the case number, you can log in and see the filing. And I've seen cases where they submitted it got rejected, and it hasn't been resubmitted. And until it's resubmitted, it's not going to get signed. And the attorney doesn't like that. They don't like me calling them on it. But I'll tell the client, hey, I'll just show them the screenshot. This is what's happening with your case. It's not a mystery. It's not, I'm not giving legal advice. This is just the procedures are right in front of you. You can log in and see it. You got to push that.
That's a great, Bill answered that question perfectly. You can go, it's all public. You have to kind of know how to maneuver through the site, but you can look up the probate notes.
Website?
Yeah.
Yes.
Well, I'm offline. If you want to reach out to me, I'll walk you through a little bit.
Okay. Thank you, Bill.
Okay, we're gonna wrap up because we're at the top of the hour. And Shadi, I know you had a long day. Shadi Shaffer, thank you so much. Now, if someone wants to contact you, your website's assetprotectioncenter.com, right?
Yes.
And if you go there, there's a picture of you smiling and your partner and your other attorneys and all the information. And you also offer free consultation. So whether you want to, if you're in probate, think you need probate, or want to avoid probate by getting a estate plan, we didn't talk as much about that today because we're going to talk about that with one of Shadi's partners, one of Shadi's associates in a future day. Today, we wanted to talk about probate and probate litigation, and because she's an expert in that too. But if you have questions on estate planning as well, go to the website, assetprotectioncenter.com, or there's a phone number right on there for a free consultation. I don't get anything out of this, but I just think she's great. 714-966-2646. 714-966-2646. We'll have that in the show notes as well. Shadi, any last suggestions or words of wisdom for us?
If you want to be a successful realtor in today's market and in California, continue following Mr. Gross. He is exceptional at what he does. The fact that you put this forum on is amazing because, look, we don't know what we don't know. And a lot of people just do not have the information. So, Bill, I really mean it. I'm not here for selfish reasons to have my phone ring. I'm thankful, the phone rings plentiful. I thank you for putting this on to educate people because so many Californians today still don't know the value the estate planning and the importance of avoiding probate. So I have a lot of respect for you, Bill. Thank you so much for always having me and being so delightful to talk to. Really, thank you.
Well,
and thank you all for listening and for your kind comments.
And thanks for making time. I know you're real busy with your conference and all, so congratulations on that. Good luck with it, and we'll talk to you soon. So that wraps us up. We do this every Thursday, 4 p.m. Probateweekly.com. Feel free, it's free. We also live stream it, and it's recorded on YouTube and Facebook and other social media. You can catch me on my social media, Bill Gross EXP on YouTube or Facebook or LinkedIn. We do this every single week. And